Ladies and gentlemen, good morning. I am Dr. Eugenia de Mura from Deakin University, affiliated to the ANU through ANCLAS, and it is my pleasure to be chairing this morning's panel. To begin with, we acknowledge and celebrate the first Australians on whose traditional lands we meet, and pay our respects to the elders of the Ngunnawal people, past and present. I would also like to just take a moment to thank John Mintz and Claudia Villegas and the ANCLAS team for actually putting this conference together. This morning's panel, Challenges of the Mining Boom for Indigenous and Non-Indigenous Actors in Australia and Latin America, promises to be, I think, exceptional. The idea behind it was to create a platform to highlight the commonalities and similarities faced in Latin America and Australia with regard to resource extraction and its social impact, in particular in relation to Indigenous rights, but also more broadly in relation to social conflict. We have 4 distinctive speakers this morning, which makes it very difficult for me to introduce each of them as they deserve to be introduced. So I will just mention a couple of very brief things. We will begin with Professor Anthony Babington, who is the Director of the Graduate School of Geography and Higgins Professor of Environment Society at Clark University. He is also Professorial Research Fellow in the School of Environment and Development at the University of Manchester in the UK, and a Research Associate of the Centro Peruano de Estudios Sociales in Peru. Then we will hear from Professor Kieran O'Farkley, who is the Director of the Centre for Governance and Public Policies Programme on Indigenous and Environmental Governance and Capacity at Griffith University in Queensland, Australia. Our third speaker this morning is Professor John Altman from the ANU Centre for Aboriginal Economic Policy Research. Professor Altman was the Foundation Director of CAPER from 1990 to 2010. And finally, last but not least, we'll hear from ANCLAS's own Dr. Zulika Arasheido. Each speaker will have approximately 20 minutes, and then that should leave us about 20 to 30 minutes for a discussion afterwards for a Q&A session. So without further ado, we'll start. Thank you.
Thank you once again for the invitation, and thank you to Zulika for putting this panel together and for inviting me to speak on this one. And thank you to all of you for coming along. What I'd like to do today is, certainly briefer than yesterday, and try and just put a few general ideas out about the context of, or concepts that might help us think about the context in which particularly Indigenous peoples engage with resource extraction. And I've wanted to use this notion of the politics of recognition as a way of thinking about some of the things that are going on inside Indigenous politics in general and vis-a-vis resource extraction in particular. And in the presentation, what I'll do is spend the first couple of slides just saying a few words about context, elements of context that I want to suggest are relevant for thinking about this particular topic that we're dealing with today, and then just go through a few different dimensions of what might be thought of as a politics of recognition and thinking about some of the issues at stake in the relationship between Indigenous peoples and extractives or resource extraction. And that's all I want to do. There's no big conclusion. It's just a few ideas. But a first couple of slides about context. I think it's helpful to recognize that, at least in the case of Latin America, where's my debris? At least in the case of Latin America, there's been kind of parallel movements that in one sense seem to be pulling in different directions over the past 20 years, and that have a national and regional dimension and also an international dimension. So on the one hand, it's a period in which one could identify an increasingly favourable context for Indigenous peoples and Indigenous peoples' politics, in the form, for example, of changes in international norms, international conventions, ILO 169, UNDRIP, and so forth, that appear to create more space for Indigenous peoples' claims in general and assertions to recognition in general. It's also a period, certainly in Latin America, more than the last 20 years, but certainly no longer than the last 4 decades, a period of seeing the progressive emergence of indigenous peoples' organizations, in some cases gelling into broader-based movements that over time have become increasingly more visible in national politics and have made certain gains. Gains in constitutions, gains in particular forms of legislation, gains in specific domains, such as bilingual education or territorial recognition. And just the nuts and bolts gains, some of the ones that Mauricio was referring to yesterday, that relate to a physical presence inside government that was simply not there 4 decades ago. There are people who can be ministers today who one could never imagine them being ministers, even less than 4 decades ago. So there's a context of gain or of a space that opens up more opportunities than was the case beforehand. But in parallel with that, I'm sorry this is all very, very kind of blunt, so to set things up as dichotomies so crudely is harsh, but the flip side of that context is one of that I want to use a couple of authors as a way of talking about the flip side. So one of those authors is Brazilian political scientist Evelina Dagninho, who talks about something that she calls the perverse confluence. And what she's getting at there is the notion, drawing upon the Brazilian experience, that there's been a kind of coexistence of, or an emergence, a joint emergence of, on the one hand, more and more spaces for democratic politics, and on the other hand, a deepening neoliberal organization of economy and society. That means, she would say, among other things, that, for examples that she would use, citizenship ceases to be really recognized as the right to have rights and really becomes the right to have access to conditional cash transfers or to participate electorally or whatever it may be. Where civil society ceases to be recognized as a domain where formative ideas in society are struggled over and becomes really a domain of voluntary action in which NGOs collaborate with government for the delivery of social programs. So she refers to that as a perverse confluence between a neoliberal tendency and a democratizing tendency that has the effect of ultimately restricting citizenship and restricting the domain of rights. Charlie Hale, a US anthropologist, has given that idea, kind of elaborated it for the specific case of the indigenous question. His work is primarily in Central America, through a notion that he frames as neoliberal multiculturalism, which is getting at the idea of a convergence between a neoliberal context on the one hand and multicultural politics on the other hand, which together means that certain cultural claims become recognized. There's a greater visibility of, if you will, minority cultural forms in society and a recognition of certain needs of those forms, such as bilingual education. But on the other hand, a context in which the material bases or the distributional bases of poverty and inequality and exclusion of indigenous peoples are simply not recognized or not addressed. So again, it's a kind of perverse confluence between greater recognition of diversity, but a refusal to address some of the structural features that lead to certain parts of that diversity being structurally disadvantaged. And when those parts that are structurally disadvantaged question those relationships, they become what he refers to, he and others, as indios prohibidos. That's not a permitted way of being Indian, to go to the streets and challenge certain structural relations in society. So there are permitted ways of being indigenous and prohibited ways of being indigenous. So part of the flip side is that more general context of advances and retrocesos in processes of democratization that Evelina and Charlie are trying to get at with some of those ideas. And then in the particular case, this is also context, as we saw yesterday and as you all know from your own work, that's seen an expansion of extractive industry that's been particularly rapid, more in some countries than other countries. But it has certain features that are really important, I think, to not lose sight of. One is that it has introduced into particularly certain rural environments really acute asymmetries of power and asymmetries of access to resources. So you have communities and groups of communities having to negotiate with companies, which may be private or state-owned companies, and the capacities to engage in a relatively equal negotiation are simply not there, whether it's in terms of access to information or understanding of information or ability to mobilize the mass media in support of the position that you're trying to project. All those relationships are characterized by acute asymmetries in which certain actors are significantly more powerful than other actors. And that's a process that's also meant that as extractive industries expanded, it's making claims on the resources and the spaces that have been occupied and used by other actors previously. That poses a question that was one of the questions I was trying to get at yesterday. Is that in certain contexts, can those two sets of not just activities, but the institutions that are related to those activities actually coexist in those spaces? So a context that you can paint as a rosy context, if you want to, ILO 169, UNDRIP, Indigenous organizations, CONAI, or you can paint as a more discouraging context, a little bit depending on how you want to frame the issue. And that's the context that I want in which groups, individuals, organizations, movements struggle not in the on the streets burning tire sense all the time at least, but struggle in just a general sense of it's a struggle, it's a bit uphill. It's a bit like the myth of Sisyphus. To be recognized. And what I want to do now, and this is just 7 or 8 slides, just to reflect on certain domains of recognition that are at stake in this process. I don't think they're all the domains, but they're just ones I wanted to refer to today. The sense of being recognized ontologically, recognized as bearers of rights, recognized as territorially constituted peoples, recognized as collectivities, to be recognized as bearers of historical claims, and as bearers of legitimate knowledge and legitimate proposals. I think there are other domains in which there are struggles for recognition, but I want to refer to these ones first in what time I have left. So what do I mean by ontological recognition? It's simply the struggle to be recognized that you actually exist, that there is a category, indigenous, that exists. And it's not no es una lucha menor. It's not an insignificant struggle to gain that recognition. And it's a complicated one. And it takes various forms, but I just want to reflect on a couple. One about boundaries and one about categories. So the struggle around boundaries is particularly related to the boundary between being peasant and being indigenous. And clearly that's a boundary that has moved over time, at least in terms of the way categories are used in the region. And that's a struggle when groups are trying to push the boundary and say that we're not campesinos, we're indigenous. That's an ontological struggle, which would say we actually exist as indigenous, not just as certain ways of producing agriculturally, or certain forms of agricultural producer. I think there are a bunch of cases in the region where you can see that struggle to be recognized differently by changing the location of a boundary. And they get manifest in discussions between movements and government, and have gone manifest, and I'll come back to this a little bit later on, in debates within government as well. And then the struggle about categories, I think, is most clearly present in the struggle to have the category of non-contact indigenous people, or indigenous peoples living in voluntary isolation, recognized. And that's also an uphill struggle. And the quotation at the bottom, I put there, it's a quotation from then President Alan Garcia in Peru, that clearly draws our attention to the way in which the rise of extractive industries makes that particular struggle for recognition yet more complicated. So Garcia said in a particularly significant intervention a few years back, he says, and against oil, the generic they, have created the figure of the if you like, the jungle native, not connected. It doesn't here use contacted, not connected. That's to say, not known, but presumed to exist. And for that reason, millions of hectares mustn't be explored, and Peruvian petroleum must remain below the soil. So there's clearly that's just, I think, a quotation that shows how the rise of extraction makes the struggle for that form of recognition that much more complicated. But it's not just Garcia. It's not just the one particular president. The case of the recent decisions around Yasuni are also, among other things, decisions that beneath them refuse to recognize the existence of or the needs of indigenous peoples living in voluntary isolation, and the apparently yet more recent decision to move on the expansion of the Camisea project in Peru by opening up Lot 88 is another case of parts of government saying, in a sense, we're not going to prioritize the possible existence of indigenous peoples living in voluntary isolation because we need to push forward the natural gas frontier in the Peruvian Amazon. Referring back to my talk yesterday, among other things, what those are cases of displacement of institutions. Displacing the institutions that existed to protect indigenous peoples living in voluntary isolation and replacing those institutions with norms that facilitate or allow access to the subsoil for exploration. So one domain of a struggle for recognition, just the recognition that you exist. Another, that you're bearers of rights. Another quotation from Garcia just before the violence in Bagua. Enough is enough. These peoples are not monarchy. They're not first-class citizens. And a sort of an association that, an argument that has gotten constructed in some of these debates, that some of the claims being made are unreasonable claims. So they're claiming special rights that are not legitimately claimable and should not therefore be recognized. But there's also a struggle. It's the claim for certain of the rights that have been opened up, among other things, by some of these international conventions. So to claim rights for free, prior, informed consent, at least drawing upon ILO 169, there's a need to also claim certain forms of identity as an indigenous person. And one can see, for example, in recent debates around prior consultation in Peru, that there is a pushback, or there has been a pushback from parts of government, particularly linked to the extractive sector, to say that certain groups should not be recognized as indigenous because therefore they would become subjects of prior consultation, and that would constitute a significant obstacle to the expansion of hard rock mining, in particular, in the highlands of Peru. Again, that's a pushback against the shifting of that boundary between being peasant and being indigenous, and wanting to keep the boundary in a place that says you're peasant, not indigenous, and as peasant you're not subject to these rights of prior consultation. In the draft Bolivian law for prior consultation, it also appears that while prior consultation rights will be recognized, a whole set of categories of activity will not be subject to consultation, among those large-scale infrastructural and extractive industry investments. It's draft legislation, though, so it's not a done deal. But a domain in which there's a struggle to be recognized as indigenous and therefore a bearer of certain sets of rights, and pushbacks against those claims to be bearers of those rights. I shall skip over this except to say that, excuse me, there's also a set of rights about just broader democratic participation. And it seems to be a recurrent pattern, and this is not just about indigenous rights, but a recurrent pattern in which the rights to certain forms of democratic participation are constrained just through the not allowing certain channels of democratic engagement to work, that almost induces forms of direct action and forms of violence as one of the few remaining or only remaining means of struggling for recognition. And that becomes kind of forcing people into the category of the prohibited Indian rather than the permitted Indian. There's a struggle to be recognized as territorially constituted bodies that confronts real difficulties with the rise of the extractive economy, which one could put up various maps. This is a map of the
TCO Vecnayek in Viamontes in the Chaco Boliviano, where British Gas have operations, and those are the lots and the pipelines. And so that struggle to become territorially constituted, which had made certain gains, the creation of the TCO, then becomes compromised by the rise of the extractive economy in those same territories, making same claims over space. And they're evident in other instances where the demand to have certain territories recognized becomes that much harder to make because there is knowledge on the part of government, or the presumption on the part of government, that hydrocarbons or other resources exist under that space. So the demand to be, or to recognize as territorially constituted bodies becomes compromised in this process. The demand, or the struggle to be recognized as collectivities is complicated in lots of different ways. But the one I just want to refer to here is that the notion that it's always difficult. We know this from all the literature on collective action. It's always difficult to form as a collectivity and to sustain a collectivity. And the particular context of extractive industries, where the incentives created are so diverse, that range from really significant opportunities through to really significant risks, and where different actors within one particular indigenous population or rural population will read those incentives differently, means that you're in a context in which creating that collectivity and holding it together qua collectivity is even more complicated. And some of those potential fissures and divisions are deliberately or by effect cultivated by additional forms of intervention that distribute benefits unequally. Corporate social responsibility interventions, community development interventions. Whether it's on purpose or by effect, I think is secondary. That doesn't really matter. What matters more is the consequences are to complicate the constitution of peoples as collectivities, because the incentives pull members of that collectivity in different directions. There's a struggle to be recognized as bearers of legitimate forms of knowledge and of legitimate proposals for different ways of doing things or particular ways of doing things. This is really the old debate in development studies about whose knowledge counts, the old Robert Chambers debate. And this clearly manifests itself, my time's up, in arguments around EIAs, ways in which projects should be monitored, what the criteria should be for monitoring, categories that would even be used in judicial proceedings, and more generally that this is back to the asymmetries, that certain actors have far fewer resources available to elaborate proposals for alternatives. Well, I think I'm going to just leave it at that, and say that if you look, just a general look at the terrain, probably say you could reasonably conclude that there's been certain progress in gaining certain sorts of recognitions, but at a certain point, that comes head to head with the broader model of accumulation characterizing society that's grounded in the countries we're talking about today, oftentimes in the extractive economy. And at that point, so often, indios shift from being permitted to prohibited when they start questioning the model of accumulation, or elements of that model of accumulation, not the whole model necessarily, but elements of it, and are not content simply to receive the social transfers financed by that model of accumulation. And lest we forget some of the nature of what happens at that moment of trying to contest the model, these are just a few images that are not mine, from the conflict in Bagua a few years ago, which became so significant for debates on prior consultation in Peru. And I'll stop at that. Thank you.
Good morning. Thank you, John, for the invitation to talk at this conference. I would like to express my respects for the traditional owners of the country in which we meet and my gratitude for allowing us to meet here. I should mention that in addition to my academic research in this area, I work as a negotiator for Aboriginal communities in Australia. I've been doing that for 20 years. I mention that because that is an important part of the perspective that I'll bring to the discussion. And also because I would like to pay my respects to the many traditional owners that I've worked with and for over that 20-year period. The idea of this session, as I understand it, is that even though each of us is only talking about Australia or Latin America, that we should open up some common themes and some potential areas for comparisons and contrasts. And I've tried to do that by focusing on three areas where I think there is a lot of commonality, and they are political mobilization, Indigenous political mobilization, responding to the social impacts of the resources boom, and agreement making. We haven't heard much. In fact, I don't think we've heard anything at all so far about the negotiation of agreements between Indigenous people and developers. But this is an area of very rapid development, both in Latin America and in Australia. So I thought it was worth touching on that area as well. I want to argue in my presentation that changes in Australia's national legal framework and the international recognition of Indigenous rights, in corporate policies and in Aboriginal communities themselves, have all combined to create opportunities for Indigenous Australians to reduce the negative social and cultural impacts of mining, and at the same time to share in the economic benefits of resource development. However, these opportunities can only be realised where Indigenous Australians have a capacity to mobilise politically, because in important respects the interests and behaviour of the state and of corporations, the other two critical parties involved here, remain unchanged. I want to emphasise in critical respects. I'm not saying that there are no changes, but in critical respects they remain the same, and therefore change only comes through Indigenous political mobilisation. What do I mean by political mobilisation? I mean, critically, the creation of Indigenous organisations that reflect Indigenous values and priorities, but at the same time can engage effectively with the state and with corporations. I mean the ability to use litigation and or direct action, or the ability to credibly threaten such action, which is actually much more the relevant consideration in Australia, to threaten the interests of the state and of corporations. I mean the ability to use the media in pursuit of Indigenous interests, the ability to engage in effective lobbying at a political level. Very importantly, the capacity to mobilise Indigenous cultural and political values and to make these values the basis for the interaction with the state and with corporations. The ability to insist on the use of processes that make sense from an Indigenous point of view. I think that the whole issue of processes around resource development are absolutely critical and deserve more attention. The ability to mobilise politically varies greatly between communities and regions across Australia. The end result is that outcomes from mining are becoming highly variable. The point was made yesterday that divisions and differences between Latin American countries are becoming as significant as differences between them and more economically rich parts of the world. The same is happening in Australia, in my view. It's not that differences and inequalities between Aboriginal Australia and mainstream Australia are disappearing, but in addition to that, differences are emerging within Aboriginal Australia because of very different capacities to mobilise politically in response to resource development. I want to pursue this argument by looking briefly at the three key actors involved, the state, corporations and Indigenous people, and then even more briefly by flagging some significant changes in responses to social impacts and in agreement making, which showed the effect of political mobilisation. Beginning with the state, yesterday Anthony talked about some new state projects that are driving change. In Australia, the situation is simpler. it is still the same national state project, particularly at the level of state governments, and that is to exploit mineral resources as quickly and fully as possible for commercial gain. That is the national project. That is also the case, by the way, at the Commonwealth level. For example, over recent years, I dealt with the then Federal Minister for Resources, Martin Ferguson, and he was as unequivocally committed to the rapid and full development of mining resources as any state premier in this country. Now, there have been some significant changes that potentially constrain the state, especially the recognition of native title by Australia's High Court in 1992, very, very quickly, and doing grave injustice to the complexities involved for people who are not familiar with that decision and its consequences. Before 1992, the Australian legal system assumed that Indigenous people did not exist in relation to any interest in property before European settlement in 1788, a doctrine referred to as terra nullius. The High Court decision said, in fact, Indigenous people owned the whole of Australia in 1788, and those rights in property could survive where people were able to show an unbroken connection to their traditional estate, and where they had not been extinguished by valid grants of land interests. What happens is that people who can meet those, prima facie can meet those conditions, can claim land, and as soon as they claim it, not when their claims are worked the whole way through, but as soon as they register a claim through an administrative process, they have what's called a right to negotiate. So the state can't any longer just issue concessions for exploration and mining willy-nilly. It must engage with those people. However, this has not changed state behaviour in fundamental ways, in my view. The same applies to international recognition of Indigenous rights. 3 weeks after the Australian Parliament ratified the UN Declaration, the Premier of Western Australia used compulsory acquisition powers to acquire Indigenous land for an LNG project. In doing so, he contravened every principle underlying the Declaration and probably at least half of its specific provisions. In relation to native title, the state complies with the letter of the law to the extent that it must, or to the extent that it's forced to, but does very little else. Just one other point about the state in Australia. In recent times, it is withdrawing from the regulation of resource industries. This will increase with the result of the election last Saturday. Our incoming Prime Minister is committed to handing back regulatory powers in this area to the state governments, but the state governments are actually walking away from it. For example, Queensland has just removed entirely the regulatory requirement for a plan to respond to social impacts from large mining projects. So what's going to happen is that nobody will regulate. Companies yesterday, again, Anthony made the point that the state is not the state, that you actually have to break it down and look at different components of it and how they act. Similarly, from my point of view, the mining industry is not the mining industry. Companies vary greatly in terms of their behaviour towards Indigenous people. There's a very wide range of policies in Australia. The question of why that is, I think, is a very open question and one we need to pursue. Sometimes people assume it has to do with scale, that big companies are easier, have more coherent policies, are easier to deal with. That's not necessarily my experience. Oftentimes, smaller, medium-sized companies are easier to engage with because they're not bureaucracies in the way that big companies like Rio Tinto and BHP and Extractive are. And if Indigenous people can engage them, often it's possible to shift them in a way that you can't with these big companies. But from my point of view, the critical issue here is to understand the strategic drivers of each individual company, and I don't think that we've done nearly enough work in terms of understanding that. And I mean that globally, either in Latin America or here. There is a world of difference between a small exploration company that desperately needs to get hold of some concessions so that they can go back to the stock exchange and raise another few $1 million, And a medium-sized company that has one iron ore mine wants to get a second one up and running before iron ore prices fall. And a large diversified global mining company with multiple projects in the pipeline and a 20-year plan to expand. We need to understand a lot more, and I think one of the huge problems with the CSR literature is that it's essentially normative. It's either saying companies should behave in a particular way, or it's descriptive. It's saying they do behave in particular ways. It's not analytical or theoretical in terms of trying to understand what's going on. This is a critical issue for Indigenous people. And in my experience, to use a cliche, one of the real light bulb moments in undertaking negotiations is when Indigenous people get access to information about the corporations they're dealing with. That has a huge impact because companies have access to enormous information about communities. They commission social impact studies, they commission landowner identification studies, they have community relations departments, and whatever the motivation for those initiatives, one result is that you get a huge flow of information about the community to the company. You get virtually no flow going the other way. So we need to do a lot more about exactly what it is that drives companies. Indigenous communities, huge diversity in Australia. Probably the single most important point I want to stress is that there is a tendency to talk about Indigenous as though it were a single category, sharing some essential. It's a very essentialist approach to Indigenous people in Australia. Indigenous Australia is enormously diverse. More Indigenous people now live in cities and large towns than live in remote areas. There is a huge difference in terms of their individual histories, the extent to which they cohere as homogeneous communities, the extent to which they are still reliant on their traditional country for sustenance through exploiting land and sea resources, their attitudes to mining. Another essentialist approach is to assume that even given that diversity within any community, people will agree on this issue. They don't. You get significant differences within communities. Why non-Indigenous people are surprised at this, I have no idea. They don't expect people in their own communities to be homogenous in terms of their attitudes to coal seam gas or uranium or whatever it is. So the picture is complex. And that flows through to their ability to mobilize politically, because all of these factors are relevant to that, and it helps to explain the difference. Okay, quickly I want to look at what all of this means in terms of responding to these two issues of social impacts and opportunities for agreement making. In relation to social impacts and cultural impacts, mining, large-scale resource development has the potential to be highly destructive in terms of Indigenous society and Indigenous cultures. It also has the potential to be reinforcing of those societies and cultures if Indigenous people are able to control the terms of the engagement. A critical part of that, a critical tool in trying to make sure that that can happen, is impact assessment, identifying the likely impacts from large-scale development, and responding to them over time. Up until the early 90s in Australia, as in most of the rest of the world, impact assessment was controlled by proponents, by the mining companies themselves, paid for by them, undertaken by consultants that they fund, and essentially they said almost nothing about Indigenous social impacts or how to deal with them. For example, in 1993, the impact assessment for a very large zinc mine, the Century Mine, in an area where the large majority of the population is Aboriginal, out of 3 volumes, an impact assessment that thick, devoted precisely half of 1 page to the social impacts on Indigenous people. At the same time, even if impacts were identified, there was no mechanism to make sure that developers and the state actually address these. What Aboriginal people started to do, initially in Cape York, which is in far north Queensland, was to do their own social impact assessments. They scraped together some funding they got their own researchers in working with Indigenous teams, and they started to put together their own social impact assessments and cultural impact assessments that focused on Aboriginal issues and Aboriginal people and on responding to those. Now, initially they were ignored, but they kept on pushing. They went to the companies and they said, we know you have an impact assessment, we're not going to accept yours. It's inadequate. This is ours. And they also went to companies and said, we don't want you just to look at our impact assessment, we want to negotiate a contractually binding agreement with you. We insist on negotiating a contractually binding agreement, which will set out how we will respond jointly to these impacts and try and minimise negative impacts and maximise positive ones. That involved a big struggle to get that accepted in Cape York, using all of the political mobilisation tactics that I talked about. But by the mid-1990s, it had been accepted, and a series of major projects were approached in this way. And literally, at the end of the impact assessment, the representatives of the Aboriginal community would sit across from a mining company in a room like this. There might be 60 people, there might be 400 people, Indigenous people in the room. And they would put their own impact assessment on the table, and they would put a log of claims, a negotiating position on the table, which included how to deal with those impacts. And they would sit down and negotiate a contractually binding agreement, sometimes involving the state as well. Increasingly, Indigenous people have been able, in parts of Australia, to ensure that that impact assessment that they do actually becomes part of the statutory impact assessment process, not separate from it. A good case in point is the recent strategic assessment of a proposed LNG precinct in the Kimberley, which is in the northwest of Western Australia, where the state government and the developers funded the Indigenous community to do its own extensive social, cultural, ethnobiological impact assessment of this project. And that was the documentation that was provided to all decision makers, state and federal. And at the same time, they negotiated agreements to ensure that something would actually be done. Agreement making more widely has become a critical part of the scene in Australia in terms of interactions around resource development. This is partly because of the opportunity provided by the Native Title Act, because the Native Title Act says that the developer and the state have to sit down with Indigenous people for a period of 6 months initially, and they have to try and negotiate an agreement which will govern the development of this project. There are other reasons, though, for its emergence, the stress on agreement making. One is because Indigenous people do not trust the state. They do not trust the state, especially over time, to address these issues, so they want to address them themselves. So if you look at these agreements, it's in a way quite surprising to find that they often include a clause whereby the developer commits to the Aboriginal people to obey environmental laws. Now you might think, well, of course they have to obey environmental laws. But Indigenous people don't trust them to. And perhaps more importantly, they don't trust the state to enforce its own laws. The effect of this is that an Aboriginal community can go to the court because they now have a commitment from the company. If they believe that the state is not enforcing its laws, they can go to the court and they can get the court to require the mining company to obey the law. So that withdrawal of the state is also leading to increasing emphasis on agreement making. Here also, though, the Native Title Act places Indigenous people in a weak negotiating position. I won't go into the details. They're fairly technical, but essentially there is enormous pressure on the Indigenous party to reach an agreement in that 6-month period. There is no equivalent pressure on the mining company because the mining company can go to a government tribunal if there is no agreement. And in almost every case where a disputed grant of a mining lease has gone to that tribunal, it has ruled in favour of the mining company. So when you have a negotiation happening, you have one party that's under the hammer to reach an agreement. You have the other party that isn't, that knows it can go to another forum and get what it wants. It puts Indigenous people at a huge disadvantage. So what you are getting is a situation where if people can mobilise politically, if they can use all of those resources I talked about to threaten the interests of the state or the mining company and up their leverage, in that way they're getting good results. But the problem is, what is happening is huge variability. We did a study recently, and I'll finish on this note, we did a study recently where we looked at agreements across the whole of Australia, different regions, different groups, and we found an enormous difference. In some cases, Indigenous people negotiating a revenue stream, negotiating highly effective responses to environmental and cultural impacts, negotiating strong employment provisions, strong business development provisions. In other places, we found Indigenous people actually opting out of rights that they have under standard environmental law. In other words, actually surrendering rights. And they do that because they believe that if this goes to the tribunal, they will get nothing. So, political mobilization is delivering great results for some groups who have the capacity to apply this. But all groups do not have that same capacity, so what you're getting is increasing inequality in terms of the impacts and the outcomes from resource development. Thank you.